Okay, I'm gonna continue trying to record videos from the cases from week 2 and get caught up. I just posted one of the videos directly to Blackboard. I don't know if that's gonna work or not, so I'm gonna keep plugging away to get us caught up. So this is the second case in week 2. This is Wynn v. Holder, and it's on page 175 of your textbook. Okay, so this illustrates for us the concept of relationship. So one of the characteristics or the qualifications of getting married is that you not be closely blood related to the person that you are marrying. Wynn v. Holder is a super sad case because it doesn't have much to do with the marriage. The husband and the wife wanted to stay married. Who brought the lawsuit? An immigration judge. So an immigration case was brought, and it involved a marriage where the husband was essentially the half uncle of the wife. So the husband was the wife's mother's brother by one parent, not by both parents. So it was not a full blood uncle, it was a half blood uncle. And those sorts of phrases, if you've noticed from this week, they used a lot of language that we don't use anymore. Half blood is offensive when we talk about it in terms of, it almost makes people sound like animals. But it makes a difference in this case. So I don't mean it to be offensive. It's relative to the statutory construction at issue here. So the question was, again, brought by the immigration judge, is does this marriage run afoul of New York's consanguinity statute, the closeness of the relationship? So let's take a look at it. Cat is worse, so I'm going to move them. And if you climb up there, you're going to be an outside kitty. Okay. So here's the statute of the law in question. An ancestor and a descendant cannot marry. So if you're in the same line, direct line, brother or sister, either the whole or half blood. And I say that because that's exactly what the statute said, and it makes a difference in a second. Or an uncle and niece, or an aunt and nephew. The question is, the statute doesn't necessarily contradict itself, but this is an opinion about statutory construction. We have a very specific statute that says sisters and brothers, either whole or half blood. Aunts and uncles, nieces and nephews. Period. Stop. End of sentence. So the court, looking at statutory construction, said, the legislature was really specific when in the second one it said either by whole or half blood. They did not say that. They said that very clearly in relation to sisters and brothers. They did not say that in relation to aunts and uncles. And they could have. And this is a case really about statutory construction. When we have a case about statutory construction, there is a long-held belief that we construe it in the light most favorable to the petitioner. And what's going on here is that the court's looking at that, and the court's saying, well, what's the reason that we don't allow people who are close to each other by blood to get married? There are two reasons that the court said. Long-held societal beliefs, the taboo part of it, and genetic defects. And the court in this case looked at history and looked at genetics, and they essentially said, well, we're not scientists, but first cousins can marry. So if first cousins can marry, I don't think the taboo is going to extend to these people here. And the defect argument is not going to extend that far either. So that was interesting. And they kind of talk about how we're not making a scientific determination, but it seems to us like half uncles are different from whole uncles on the genetic defect with children issue. And so the court said it was not the legislature's intent to avert that small genetic risk, and that this marriage would be valid. I think it's really sad because it's an immigration case, And we don't know whether or not these people got married to run afoul of the immigration rules, but if they had, that probably would have been part of the case. It probably would have been not that this marriage is invalid, but that it was a sham marriage. What this case is important to illustrate to you is that, yet again, we have another example of a kind of law that comes into play or is affected by family law. And a lot of people don't think about how immigration law is very much affected by family law, or the two are very much effective on each other. And so the other thing about this case that the court doesn't really talk about, and maybe that's because it really was a legitimate marriage, is that they were married in 2000, and this case didn't go through the court until 2014. That's an awfully long time to maintain a sham marriage, and the longer a marriage exists, the more likely it is to be seen as valid by the courts. So that was probably less of an issue. So I find it interesting. I'm going to keep on rolling here and see how much my computer's camera can record. Okay. Age. Porter versus Department of Health and Human Services. This is the case I find just absolutely fascinating. And there was a question in one of the question boards. It was a great question, and I said I would take a look at the full case and get back to you, and I have. And the full case is far more illustrative on the topics that the students had questions on than this particular excerpt, and it's kind of interesting what's going on. All right, so this is a DHS case. There were 2 children where a Department of Health and Human Services, sometimes we call it CPS, Child Protective Services, depends on the state you're in, stepped into a family and said, these children are being neglected. And this is an appeal of that. And the oldest child, the 16-year-old, had married a 34-year-old with her parents' consent. Now, there is some back and forth as to whether the parents really knew he was 34. They certainly knew he was at least in his 20s, and they didn't make a whole lot of inquiries about his actual age. And so there's a finding of neglect, and the mother doesn't challenge it. She goes along with a reunification plan and whatnot, but the father challenges it. The father challenges it because he said that the ruling finding neglect was based solely on the fact that he consented to his daughter's marriage. And that was a legal thing for him to do under the statute in effect at the time. He could give consent, and he did. There was a colloquy in the case as to why he gave consent. So he said, I did a legal thing that shouldn't be held against me. And the court looked into a couple of things. So in part and parcel with that, I didn't do anything wrong, I also didn't know he was 34, so I wouldn't have done that legal thing that I got in trouble for. Had I known, I want to annul that marriage. So the action that we have here is to nullify that marriage based on fraud, based on mental capacity of the 16-year-old, based on her age, trying to void that parental consent. Now, one interesting thing is that this is a 2008 case. There's been a movement over the past 10 or 20 years, I think I've talked about it, to raise the marital age to 18 across the board. That happened in Arkansas, or at least they tried. But there's a statutory issue, and this issue does not appear in your excerpt. It appears in the full case. And so by the time this went to court, there was a change in the statute, trying to change it to 18. And because of an issue statutorily, the court said no. I don't have it in front of me to tell you the exact rationale, but they based this case based on the previous version of the statute because the new one statutorily had some problems with it. So I'm sure it's been fixed by now because this is a huge trend to up the potential age of marriage. And the other thing the case talked about is that the old statute was had a different age based on whether the wife was pregnant. And so there were, like, some states will have, you can get married at 18, you need parental consent if you're under 18, unless you're pregnant, and then you don't if you're over 16. Like, it's pretty convoluted, but to me, it's if she's pregnant, she could get married younger. It's not the greatest argument to make. Just because we don't know that this person consented to having a pregnancy. We don't know that she's a good parent. We don't know that he's a good parent. Again, we see how parenting and marriage go hand in hand. Just like in the discussion board we talked about last week, where in some states you have to have counseling, figure out how to parent, co-parent counseling before you can get divorced, because that parenting piece and that divorce piece are together. Same thing with these underage marriage statutes. We're going to favor pregnant teenagers getting married. It's not exactly a shotgun, but it's the legal equivalent of one. Okay, so the court goes into great pains to determine whether or not the marriage is valid based on the consent of the father being fraudulent because he did not know the husband was 34, based on the young girl's mental capacity. And the court did a really good factual analysis and said, no, everything was fine. The girls, in the full opinion, the girl's therapist testified that she was kind of wise beyond her years and that her mental problems in life were because of her parents and that she felt abandoned by her father, that she was smart and she was making decisions on her own. And so that testimony was there. The mental capacity testing, and some of that is in your excerpt as well. The court also said, we can't say that there was fraud because of the testimony that the parents said, well, we saw him and we knew he was at least 20 or over 20 or in his 20s. And then when we saw him, kind of looked like he was over 30. And then they didn't ask him anymore. So the court was like, well, how is that a misrepresentation? And the court said it wasn't, so the marriage was valid. So what's interesting about this case is a couple of things. One, the statutory construction arguments about how the change in the statute did not stick, essentially, for this particular one, and the neglect issue. All right, so the question in the discussion board was, how can it be neglect? She's emancipated now, because one of the things that we haven't talked very specifically about is that when a minor gets married, whether through the consent of their parents or in a state where it's not required at whatever their age is, they are typically emancipated. Now, this is a point of juvenile law, which also dovetails into family law. That emancipation, for most purposes, makes them an adult. Their parents don't have to support them anymore. They make their own decisions. They can enter into their own contracts. But, so I was asked the question, would her emancipation go away? And my answer was, well, that depends on the statutes involved in the case. But I have based on that student's question, I have another question, is that the court here said, it doesn't matter. It doesn't matter whether her marriage was valid or not to the finding of neglect and the subsequent involvement of the court in this child's life. So let's think about what that means. This child, if found to be a child in need of services and found to be neglected, found to be dependent, in need of services, even if they are legally married and that marriage sticks, can still be essentially a ward of the state for purposes of a DHS investigation, a DHS case. The court said that, and that's what I thought. Why would a court supervise a child who's not a child anymore? Or why would the DHS do that? Well, the issue is in the case. So the case goes into detail about a particular statute that says, even if a child is married, it defines child as under 18, period. And even if a child is married and perhaps emancipated for purposes of contract, for purposes of support, they are not outside of the jurisdiction of DHS. So the court looked at a very, very specific statute that said, even if this marriage is a good marriage, and they cut all of that out of your excerpt, and they just leave you with these little ellipses. But even if the marriage is valid and it stays valid, we are going to allow DHS to be in the life of this family, this child. And the statute was very explicit and it was very concise, and that's what they based that on. I find that super interesting. This can be a conflict. So my question is, and I don't know the answer to this, so let's say she's emancipated. How can she contract? Well, she can get out of her marriage until she's 18. Is a contract voidable for purposes of a car dealership, let's say, if she's emancipated by marriage? So if she gets out of the marriage, can she get out of the car sale too? I don't have the answer to that. Based on this Arkansas case, in Arkansas, I would think yes, that makes sense. But there are all these issues that come into play, and no one person's going to know all of the things. We might be able to find them out, but there's all these different issues, right? And I just find it super interesting. So the other conflict that I wondered was, okay, so if she got emancipated, because the marriage stuck, marriage is a good marriage, and the court said, well, there were other bad decisions that dad made, so the finding of neglect stands. There was also another kid involved, so there were some more factual determinations in the full version of the case. So let's say she's emancipated by marriage, so her father does not have to support her anymore. That's part of emancipation. But DHS is still authorized to supervise her under a finding of abuse or neglect. What happens when DHS takes custody of your children for neglect? You have to pay them support. So if the father doesn't have a duty to support her, might the father have a duty to pay the child support he would normally pay for her to the Department of Health and Human Services under that particular statute that the court was looking at? I don't have that answer. That's a brief. That's a big one. I don't have the answer for that, but I think it's super, super interesting. Okay, and we're going on 20 minutes now, so I'm going to stop this video and start another one.